Involvement with the criminal justice system is life-changing. It matters.
Having a justice system that works is a really important part of a democratic society.
I'm Penelope Gibbs, Director of Transform Justice.
I'm Rob Allen. I've worked in and around criminal justice all my career.
This is the Transform Justice podcast, throwing light on the criminal justice system.
Hearing from people who know.
It's about whether the system's fair
and what can be done to make it better.
Hello, today it's just Rob Allen and I chewing the fat about what's going on in criminal justice. Not the whole of it, of course, but about some new developments in sentencing and about the single justice procedure, one of my hobby horses.
Well, yes, Penelope, I remember we talked about the single justice procedure on our very first ever podcast. Remind us what it is.
It is still pretty unknown, even though it accounts for the majority of all criminal prosecutions in England and Wales. What it is that if you commit a minor crime, we're talking about something like not having the right ticket on the bus or not paying your TV licence, the prosecutors are the companies concerned, so it could be the BBC or the train company, and they prosecute you for it, and it's all done in the post or online. There is no actual court hearing. You just get sent this notice in the post. You fill in whether you're guilty or not guilty. And then most people either don't fill it in at all, in which case they're assumed to be guilty, or else they say they're guilty. And it's all done in a closed court by a single magistrate sitting alone. And the punishment is always a fine plus paying the costs of the prosecution.
I mean, it's something that has received an increasing amount of attention, I'd say, over the last few weeks and months. Might have been down to our podcast, but do you think there are some other factors that have led to it, a growing concern about it?
Great though our podcast was, the real burst of interest is since the series on ITV about the post office scandal. And the reason why that sort of prompted other articles is I think journalists have thought, ooh, what else have we missed out on in terms of kind of massive areas of the justice system which are going wrong? And they have trawled around and found the tweets and articles of our podcast guest, Tristan Kirk, who is the court reporter for the London Evening Standard. And he has been writing about this and uncovering the worst aspects of it. And actually, what's coming out is more and more concerning in that he's recently got hold of the actual paperwork that defendants fill in, including the reasons why it happened and some context about the person who did it. And some of those are pretty shocking because actually what appears to be happening is quite a lot of people are very vulnerable who have been prosecuted, and there are valid reasons why they didn't do whatever the crime was, or they have a good defence for it.
So that's one of the main shortcomings of the system that Tristan's unearthed, is it? I remember him talking a lot about this is all done behind closed doors, nobody really knows what's going on. What are the kind of things that he's unearthed?
So what's never been done before, I don't think, is people actually getting hold of this paperwork because these cases are held behind closed doors. It's not an open court. And there's some hair-raising examples where people have been prosecuted. So somebody was prosecuted who was 83 and had been in a care home for a few months for their car not having insurance. Now, this car had been in a garage for 2 years, and this guy's in a care home. And in the end, his daughter writes in and says, you know, these are the reasons why he doesn't have insurance on the car. And in fact, he was still convicted. He did get what's called a conditional discharge, which is the least you can get, but he was still convicted. Or we've got another 90-year-old whose wife has dementia. His wife threw away all the prosecution notices, so he didn't actually get it. And what this shows is that there's no what's called public interest test done in these cases. So normally with the Crown Prosecution Service, one of their principles is that all prosecution actually does have to be in the public interest. And you can weigh up the public interest according to things like somebody's in a care home and they haven't used their car for 2 years. To be honest, I'm a critic of the CPS, but they would never prosecute in those circumstances if they had that information. Whereas what Tristan's work has shown is that the prosecutor never gets that, what we call mitigation, those reasons why. So nobody's actually sitting back and saying, is this prosecution the right thing to do given this information? They don't have the information or don't gather the information. And so basically you have got wrongful prosecutions going on.
But how much of that is down to the fact that it's a single justice procedure? If these cases were continuing to be prosecuted in a court, would the prosecutors discontinue those prosecutions? Would they get to know about these factors, or is it really a prosecution problem rather than a single justice problem?
It's a problem with this process, which is that there's no step in it for the prosecutor to get information about the vulnerability of the defendant and circumstances like the car's been in the garage for 2 years. It just appears that they've got certain information and they just press a button for prosecution. So it's missing that critical step, which frankly needs information and would be costly. But, what is the point in a justice system if we're just doing cost saving but without the justice?
Okay, but the magistrate sitting on their own online who looks at this, they do have this information.
They do, but I don't think they have the ability to reverse the prosecution.
So they can't throw the case out and say, look, this is not really...
If the person ticked guilty on the form, that's the problem. But the people who are prosecuted don't know what it means for this to go ahead to a conviction. They don't know that things like 2 years in a garage would actually, in an open court of law, possibly make the prosecution withdraw it, or even before you get to the court of law.
And these kinds of cases, and I suppose a lot of these kind of people aren't the ones who are going to consult a lawyer before ticking that guilty box.
There's no legal aid for these cases whatsoever. There's a court service phone number, but they're only around, 9 to 5, and the phone calls cost. And I think most people think that if something happened, they must be guilty. But the law is much more complex than that. There's something called viable defence, and there's the public interest test. And these defendants don't know any of that stuff. And they're not at any point offered the opportunity to challenge the prosecution on the basis of public interest.
No, that sounds pretty worrying. What, if anything's happening about this?
I mean, this is where it gets a bit gloomy, I have to say, because even though there are these articles, there is radio silence from the government and from, for the most part, the judiciary. So it's almost as if they're just hoping this issue will go away because they don't want to uncover the problems and do anything about them because they are considerable and obviously it would cost. So I've been begging the Justice Select Committee in the Commons to do an inquiry about it. Hasn't happened. There are a few MPs, including the Labour MP Wayne David, who have actually, to their credit, taken up the cause, and that's partly because of Tristan's work and the media articles. So it's an interesting one because there now have been quite a few articles, and you kind of think, to be honest, what more does it need to actually get something happening?
And what about judges? They have overall responsibility for ensuring a system from top to bottom works justly as well as efficiently. Are they showing any disquiet about it?
Magistrates are in the main absolutely silent about whether they think there are problems with this system. Senior judiciary, I think, to be honest, don't really understand it. So Tristan Kirk asked the Lady Chief Justice in a recent press conference about the single justice procedure. And she said, oh no, it's everybody can have a trial if they want and an open hearing and so on. And she didn't buy his contention that there were significant problems. And the fact is, A, the paperwork doesn't make it at all clear that you can go for a trial in open court. But secondly, actually, the problem is with the system of those who plead guilty. It's not an issue of trials. It's an issue of the people pleading guilty and the system that they are subject to.
What would you do if you had the power to attend to this issue and try and fix it?
I would look at this prosecution process and the response of defendants to it. For one, why do so few people plead guilty or not guilty? So most people don't plead at all. And that, to me, is a justice system that is not working. You know, maybe they do receive the envelope in the post and put two fingers up, but for 3/4 of people to ignore a criminal prosecution, something's not working. We need to build in a step to judge whether these prosecutions are in the public interest, a step which is not there at the moment. But what we're talking about here is an unfair process. The sentencing is pretty consistent in it being a fine. There is a faint possibility that if they don't pay the fine, they will be sent to prison. But I've never heard that happening. Whereas at the other end of the spectrum, what we've got in England and Wales at the moment is prisons full to bursting, and in Scotland, in fact, as well. And what I'd like to look at with you, Rob, is the sentencing which is actually driving that. Do we have more people actually in prison because more are going, or because their sentences are getting longer, or both?
I think it's a bit of both. And one other factor. So the numbers being sentenced have kind of gone back and beyond sort of pre-pandemic levels, because obviously there was a sort of break on the system when we were in lockdown. And because the government have recruited more police, the numbers coming into the system are going up. That's led to more people being on remand in custody. And I think the immediate prison overcrowding crisis is in large part caused by this big surge in remand numbers.
That's pre-trial imprisonment,
so
isn't
that's
it?
before people are sentenced. But, and it's a big but, the big trend over the last 10 years that has continued pretty well unabated is more people being sentenced to prison as a proportion of all those who are sentenced. It used to be about 1/4 of the more serious cases. It's now 1/3. And longer sentences. So the average length of sentences imposed by the courts has gone up by several months on average. Plus, the government have introduced some new measures. So some offenders, sexual violent offenders in particular, spend more of that sentence behind bars and are less eligible for early release. So all of these things kind of mix together, but harsher sentencing is at the heart of it.
You say harsher sentencing, and one might think that that's about new laws, new legislation. But is it just the new legislation, or is it that judges are actually getting more punitive in the way they sentence?
Yeah, again, you're right. It's probably both. Parliament has legislated. We did a podcast a little while ago on the issue of assault on emergency workers, which I know is something that you've campaigned on. That the maximum level for that offence has risen twice, I think, over the last few years. So legislation has played a role, but the rise in the sentencing, custodial sentencing rate, and this increase in the average sentence length, it is down to what judges are doing. It's possible that they are dealing with more serious cases than they used to be. Some judges explain this increase in that way and say we deal with much more serious cases on average. That's why we're sending people to custody more and for longer. But I think it's not really tenable to think that that could be a complete explanation of this. For whatever reason, courts are harsher today than they were 10 years ago.
So we're talking about the same kind of crime with maybe the more or less the same profile of the person committing the crime, and they are sentencing that person for longer than they would have done 10 years ago.
Yeah. I mean, the only caveat on that is that courts are required to treat previous convictions as an aggravating factor, as a factor that makes an offence worse. And there is some evidence that there are perhaps more people coming into the courts with a longer string of previous convictions, and therefore the courts are reflecting that. But again, that's only a partial explanation, a very partial one. And it's a strange rule, that really, this idea that if prison hasn't worked in the past, we'll give it another go because somebody's got previous convictions. Why not try and find something that is more likely to get people away from offending and on the straight and narrow?
That makes sense. So, what we have that guides judges in how they sentence is something called sentencing guidelines, which are created by the Sentencing Council. You've written for us, Transform Justice, about how you've analysed their data and think that actually the Sentencing Council guidelines themselves are causing some of this sentence inflation. Are you still concerned about that?
I am. I mean, not everybody agrees that the guidelines have necessarily been the sole reason for driving up sentence levels, but I think everybody agrees that the council could do more to maintain sentencing levels where they are and perhaps drive them downwards. For an example, they're consulting at the moment on a guideline for offences of kidnapping, false imprisonment and blackmail. Fortunately, not terribly common offences, clearly very serious offences. The overwhelming majority of people get prison sentences for those. But these draft guidelines, for each of them, suggest the response needs to be yet harsher. We need more prison places to deal with what happens after this guideline comes into effect. And I wonder why that was deemed necessary. And I worry about the kind of ratcheting up effect that kind of guideline might have on lesser offences. I was hoping the Sentencing Council would ratchet down.
So in the case of that guideline, the Sentencing Council have just suddenly said, oh, well, you need to sentence more harshly. How have they justified that?
Well, the reasoning is a little bit opaque, I think. This is what I mean by the ratcheting up. If sentences are going up and somebody comes along and says, OK, what should we have as the going rate for this? Look at what sentences are for similar offences or other offences that may be less serious. They feel they need to put in a bit of headroom between, the sentence for something, assaults or something like that. We end up creating harsher and harsher sentences. And I think the council needs to do more to stop that process and draw a bit of a line in the sand.
I mean, I agree. But what's interesting about the council, though, is recently they've published a few really interesting research documents. One about, to be honest, the uselessness of particularly short prison sentences in terms of reoffending, but also about racial bias within sentences. And they've admitted via research that actually some sentencing does seem to be racially biased. So on the one hand, they're doing this stuff which seems quite positive in amongst the more negative stuff.
Yeah, I think it's very good that they have recognised these racial disparities in sentencing and they're encouraging courts to take proper consideration of that.
To not do racist sentencing, in other words.
Yeah, but perhaps ask for pre-sentence reports to find out a little bit more about the background of people, because those are something that have rather gone out of fashion. So I think it's good. We did a podcast, you'll remember, on racism in the criminal justice system, and I think our experts then, if they were here, would say, don't hold your breath about that necessarily making too much difference. But I do think there's quite a good draft guideline, as you mentioned, about imposition of custody and community sentences. It's, okay, what should courts be considering? What should they take into account before they send somebody to prison? And I think that is much more positive than the existing guideline. As I say, they're encouraging more reports from probation so that they can take into account a much fuller picture about why somebody has got into the trouble they've got into, particular interest in women offenders, particular interest in young adult offenders, and trying to see whether there are alternatives for these people. So I think in that way they're going down a more positive line than perhaps they have since they started in 2010-11.
That will be music to their ears, Rob. Meanwhile, there's a mixed picture with the Sentencing Council. There's also a mixed picture and slightly confusing messaging from Parliament. There are bills going through which will profoundly influence sentencing, aren't there?
Yeah, there are. There's 2, maybe 3 that are relevant here, and it's not on the face of it a wholly coherent policy or picture that they're putting. I think the government would say, look, our underlying policy is serious, violent and dangerous offenders need to have longer sentences and stay in prison longer. Less serious offenders can be dealt with through suspended sentences. You don't go to prison, you are subject to conditions and requirements in the community. So there's this quite significant idea of requiring courts to presume that sentences under a year should be suspended. But also they want to increase the use of home detention curfew. This is early release on an electronic tag. So on the one hand, they're kind of saying we want more people in prison for longer. On the other, they're saying we don't want more people in prison for longer. They would say the distinguishing factor is the seriousness, the violence. So there is some kind of logic, I suppose. My worry is that the harsher sentences for the more serious offences will definitely happen. The suspended sentences and the early releases for the less serious ones may happen, they may not. It will depend on how courts interpret the provisions in terms of the suspended sentences, how the prison service takes up the opportunity to release people on electronic tags. So we could end up with quite a big increase in the numbers of people in prison if the increases happen and the decreases don't.
I'm more confident that prison governors, given the chance, will release people on tag if it's their responsibility than I am necessarily that the courts are going to do this not using short prison sentences. Because the example of Scotland is that where they brought in this thing of trying to, as it were, almost get rid of short prison sentences, it hasn't really worked, has it?
It's worked a little bit. I think the number of short sentences has declined, but there is a risk, of course, that some people end up getting longer sentences to avoid being in the under 12 months if somebody...
So basically the danger is that a judge goes, I can't do a 11-month sentence, so I'll give this person a 13 or 14-month sentence.
12 months and a day. There's a risk of that. I think a bigger risk is ensuring that if people do get a suspended sentence, they come to the probation service for supervision, and hopefully not just supervision, but support, help, and so on. Is the probation service going to be geared up to do all of that? I mean, we hear a lot about staff shortages in prisons, which is putting a lot of strain on the prison system. Probation has got its own staffing crisis. I think the corner's being turned, and it will be terrible if we didn't go down this road because of concerns about the probation service. But I mean, the other thing is the people that we're talking about are often people who have chalked up a fair number of previous convictions. And some judges would say, look, it just gets to the stage where they've kind of run out of road. They've had chances, they haven't taken them. So they would say, look, we do suspend sentences if we can. So how big is this group that we can, hand on heart, say, okay, we're going to suspend this sentence? And how many are going to say, actually, we can't do it? There are exceptional circumstances, and therefore you're going to have to go to prison. And the answer is nobody knows how much it will work. And that's why the government themselves have produced a kind of impact statement, which ranges from freeing up 200 prison places to freeing up 1,000. I mean, that's a big range. But even at 1,000, it's not going to make a huge dent on a prison population of 87,000. I
think this short prison sentence thing is interesting, and obviously I have heard judges talking about, they've had their chance kind of thing. But recently the College of Policing brought out what they call a meta-analysis of the effect on offending of imprisonment. And it was pretty clear, actually. So this meta-analysis looked like tons and tons of studies across the world about the effect of imprisonment. And it says, this analysis of these other studies, that imprisonment doesn't work, whether it's short or long. So it doesn't work. It increases offending versus other things you can do in the criminal justice system. So I think it's an interesting one, and I really, really hope myself that we will more or less get rid of short prison sentences.
Yeah, I agree. So can I ask you, Penelope, in the middle of all this legislation, there's a proposal for a new offence of assaulting a shop worker, and I know it's something you've got some concerns about. Why and what's happening with it?
I mean, I think the assault of shop workers is terrible, and obviously we need to deal with it. But I mean, I think the example of this proposal just shows that some of the thinking about how the criminal justice system works is just not based on evidence. So on the one hand, we have proposals to get rid of short prison sentences, and on the other hand, this proposal about this particular offence says that the penalty for the offence, the maximum penalty, should be a 12-month prison sentence rather than a 6-month one. So this is in amongst all this conversation about how short prison sentences don't work. And it just seems an example of a belief that if you ratchet up sentences and create a specific offence here, which is assault shop worker, which may kind of draw attention to it, that will deal with the behaviour, which, is terrible. I don't want to see shop workers abused, but all the evidence says that this offence is not going to do what the shopkeepers want, which is really for the police to actually go and deal with the incidents. They're less bothered about exactly what kind of sentence that person gets. So it's been opposed, interestingly, by the government, who actually do talk about ratcheting up. They say, if we do it for shop workers, then the social workers will ask. If we do it for social workers, then the security guards are going to ask for it, and so on. So they say this would ratchet up sentences, across the board. So it's unlikely to go through in this Parliament, I have to say.
Well, that's encouraging that the government are sort of sticking to their guns in terms of the ineffectiveness of short sentences in the face of a proposal to kind of increase them, as you say.
So, Rob, if you were Lord Chancellor, and we've been talking about sentencing, but particularly about this sentence inflation, which is fueling, our very high prison numbers, what one thing would you do to maybe try and halt it?
Well, can I sneak in too?
Rob?
I know it's our golden rule. One thing I've been thinking about, and the Lord Chancellor mentioned that he was looking at it, I would increase the discount that people get if they plead guilty to an offence at the earliest opportunity. Why? Because that would reduce the number of people on remand, and it would bring down sentencing levels, because if there was a decent discount, people would get shorter sentences if they pleaded guilty earlier. But in the longer term, I think we really need a dispassionate look at sentencing levels across the piece. I'm sorry to come back to the Sentencing Council, but I, as Lord Chancellor, would ask them to do that with a view to reducing those levels and replacing imprisonment with more constructive non-prison alternatives, restorative justice, and other community-based measures that can be far more effective in reducing reoffending.
Not sure I agree with your first one on a greater discount for guilty pleas, because I worry about people being pressured to plead guilty. But I absolutely agree with your idea about reform of the Sentencing Council. As usual, if you'd like to find out more information about what we've talked about, do have a look at our programme notes. And if you'd like to be alerted to each new episode, and next is probation, do subscribe on whatever platform you use. Thanks and goodbye.
Goodbye.